Hello. Thanks so much for joining me this morning. This is John Miller, founding attorney, senior attorney at Rock Solid Law, celebrating our 30th year of independent practice located in beautiful Jacksonville Beach, Florida. Uh, Continuing our series of Thursday morning webinars, Zoominars, and we will keep doing them as long as folks keep showing up for them. Really enjoy being able to share some information on these short, informative sessions. I was really surprised that I have not actually taught as a subject probate in about a year, which is a bit surprising. I will tell you, our firm is blessed to be very busy and growing. And I attribute that in part to one pandemic allowing people to realize the mortality of these bodies that we're encapsulated in, and that they do have a life expectancy and a termination point. So you want to plan for what happens for you and your family. And one of the things Rock Solid loves to do is help keep Florida families, American families strong. We want to protect the family tree, not allow folks to burn it down. Those of you that know me that are online know that I've practiced law now 37 years, and I have seen a lot of scenarios where people have not planned well and families have fought. And very sadly, I've seen siblings that'll never speak again. And there are people that are like that. I can't fix everybody, but through good planning, we can set it up where folks don't have the opportunity to cause fights, absent huge hurdles to get to that point. And we're going to talk a little bit about that this morning. Rock Solid Law does three things. We close real estate title, that's homes and commercial properties, professionally and on time. I believe that home ownership is the cornerstone of the American dream. I had a couple of brand new first-time homeowners in the last 2 weeks, and nothing thrills me more than to work with those folks. Also, I began my practice in litigation and commercial litigation, meaning I worked for businesses. I transitioned, over 20, 25 years ago, now out of litigation and into representing small business owners. And the reason that I love working with our small business clients and helping them be profitable is because I truly believe small business is the heartbeat of the American economy. And small business is about 95% of all business. And being an entrepreneurial small business person myself, I really love working with small business owners. When I came to the beach 30 years ago and opened my firm, there were a few other lawyers. I think there were 8 or 10 of us out here at the beach, and then some guys that practiced only real estate. And so I was a generalist doing a little bit of litigation, and then began working more and more with business clients, and realized very shortly thereafter that I could not well advise or thoroughly advise my small business owners without getting involved with what's happening to their family. And out of that need grew my inquisitiveness to add estate planning as a part of the practice. So for the last 25 years, that side of the practice has grown. Those of you that have been on these regularly know that I have, within the last 18 months, been invited into a national consortium. I call it a team. I like team. Including lawyers that are literally some of the top 20, 25 lawyers in the country in estate planning, so that we have the ability to now represent common folks and really the highest in wealth. I mean, I work with people that have worked with presidents and Nobel Peace Prize winners and captains of industry. So it's really a cool journey for me. And I love to be able to offer that level of expertise to the people that I have the good fortune to work with. So that brings us to today, because probate is really a part of the estate planning process. And in many, many instances, it is part of the lack of planning process. Probate is what happens if you have no plan at all, if you do absolutely nothing and want to let the state determine what happens to your assets after you're gone. Or probate is what happens when you have a will but no other planning documents like a revocable living trust or some other document which keeps you out of probate. And we're going to talk about a little bit why that might be a good choice for you. But going into it, I want to say that I met with a potential new client, somebody I'd known a long, long time last week. And we talked about what his assets are and what his family situation is, because I like to get to know the person before I can make a recommendation, pardon me, of what they should best do. And you know what the best thing for him to do was? Nothing. He really didn't have enough assets where even a simple probate was ever going to happen, as long as he titled a few of his assets in the name of the family member to whom he wanted them to go, sort of as a beneficiary or payable on death, transfer on death kind of things, on the bank account or trading accounts, those things. So that's one of the things I think is a real service that attorneys in this area can do, is when people don't need anything, don't sell them anything. Tell them what to go do and send them on their way. And with this fellow, the big question was who would get his bicycle, right? I mean, he had more assets than that, but that was his big question. I don't know what's going to happen to my bike. We joked together, and I told him what he needed to do about his stuff. And fortunately, he had served our country, for which I thanked him immensely, being from a long line of soldiers myself. And he was able to get some of those ancillary documents through the VA. So he really, I made the session complimentary, and he didn't need to pay me anything at all. The only reason I tell you that is that can be the case. It's unlikely it's the case. It's the case when you have very small amount of assets. Really, it's for the bottom 5% of owners and savers and earners, savers, and owners. But that will be the case sometimes. Now, for people that have accumulated less than, say, $70,000, a summary probate process isn't a bad one, as long as they don't leave creditors behind for their family to deal with. So for people that that might not have accumulated very much in assets, the probate process may be a good one. In my opinion, for people that have accumulated a home, perhaps several $100,000 in various other things that they own, retirement plans, stocks and bonds, bank accounts, investments, other real estate, anything like that. I believe that we need to at least examine trying to keep them out of the probate process. So big picture, estate planning is about celebrating your legacy, right? At a time of probate's being considered, that means someone has passed on, whatever you believe, to the next world or to a better place. I have one client who's an elderly guy, and I just love him. And he keeps talking about, well, when I do kick the bucket. So somebody's kicked the bucket when a probate's being considered, and some family has gathered together, and hopefully you left behind a plan so they can celebrate your legacy rather than fight over you after you're gone. So our effort through whatever plan you decide to go forward with is to tell your story to your family and those you love based on your values. And here at Rock Solid Law, we call that showing your love to those you treasure. Showing your love to those you treasure. That's really what the process is about. And that's why you really need to know what probate is about, because if you or some lawyer intentionally puts you through a probate, there's a real big chance that the people that you love most aren't going to be happy with you, right? So what does it mean to have a will? What is a probate? If you've got a will, congratulations. You're in the top 20% of Americans, according to the Financial Peace Institute. I taught the Dave Ramsey course a few years back through my church. And he would tell you that 80% of folks have no plan at all, or they have one that is so outdated, they might as well have no plan at all. So a will means you've decided who will take care of your affairs, who will take care of your children if you have minor children, and who you want to receive gifts from you after you're done with what you've got. With a will, those that you love will be involved in a lawsuit that's called a probate. There are several things to know about a probate process, and that's what we're going to spend a good few minutes on here in just a second. If you've got a pencil and pen, paper and pen or pencil, writing utensil available, I got a quick quiz for you. Ready? You don't have to turn your grades in. While you're getting that pen together, I'll remind everybody somewhere about right here in your screenish, there is a chat bar. And I'm happy to field questions, which I typically answer at the end. But if a question occurs to you and you want to put it up there, if it's right in the flow of what we're talking about, I may address it during the main part of the lesson. So you ready for the quiz? All right. After you die, or the second of you in a married couple dies, do you want your closest family secrets to be private or public for anyone to see? Kept private or public for anyone to see? Question 2. Do you want your estate to be distributed quickly to whoever you've chosen to leave it to, or whatever? Could be charity. Love to help people with charity. Or do you want it to be in a long, drawn-out court process? And finally, 3, choose all that apply. Who do you want to receive what you've worked for after you're finished with it? A, people you love and or care about. B, charities or others that affect your legacy. Or C, people you dislike immensely, lawyers you don't even know, accountants, appraisers, phony creditors, etc. Obviously not much of a test there, right? Those 3 questions. But you know what? When folks go through probate, the skeletons in their closet are on display at the courthouse for anyone to see. A probate process will be no less than 6 months in almost every occasion, and probably more likely 1, 2, and I've seen even 3 to 5 years. And finally, the people that are going to get your money or whatever you leave behind, it's probably some lawyer you don't know, the accountants, the appraisers, the other people in that probate process, including even phony creditors. You know how many scam artists there are out there. There are people out there that watch the probate files and file a claim just on the off chance that the heirs will pay it, rather than try to figure out whether they really owed it or not. Isn't that gross? Makes me mad. So guess what? 80% of Americans go through probate. As 8 out of 10 or 4 out of 5 of everybody you see walking down the street. Let's see how many there are. There are over 10 of you on this call. So there are going to be 8 of you that are going to have a probate process. All right. So to reiterate, probate gives you unwanted publicity, your dirty laundry in public, a long time until your heirs receive your gifts, including money, which they may need for your celebration or to pay off some of your debts or keep your mortgage current. And people you don't like or even know are going to benefit from what you've earned. Maybe the worst part is your loved ones are going to relive your death every day until that probate's over. Canceling golf, canceling tennis, canceling outings that they want to go to, maybe trips and vacations, because they have to be at the courthouse because of your probate. All right. So probate is a lawsuit that gets filed with the will at the county courthouse, right? It means a judge is in charge. You guys know, or most of you, I think, that I'm a special magistrate, a municipal judge for the city of Neptune Beach. So I can say this. Judges are appointed by politicians, including yours truly. So basically with the will, you're putting somebody who is appointed by a politician in charge of the distribution of what you've left behind. All right. So with the will, there will be that process. There will be likely, unless you have less than $70,000 in assets, a formal probate with notice to creditors, an opportunity for creditors to come out of the woodwork. Also, it's the opportunity for family to fight. Probate cases are where siblings, other family members fight each other for whatever is left behind. Okay. It's long, it's drawn out, it's expensive. In fact, the probate process probably, in almost every instance, ends up costing more than what it would have cost to set up a revocable living trust during lifetime and eliminate all these hassles. Okay. So with a will, the first problem is that nothing is done to alleviate the undue cost, stress, delay, and publicity of a probate process. All right. You're going to be dealing with your heirs, are going to be dealing with and paying a lawyer. And hey, I've had people say, you know what? That's my kids. Let them pay. And you know what? If that's your decision, have at it. I'm all in favor. But I want you to know what's out there. Some of the most motivated clients I have to get their own estate planning done have just been through the process with their parents. We're the sandwich generation. We take care of our parents, we take care of our kids, right? So going through that, they realize, I'm not doing that to my children. I define probate as a voluntary tax you impose on yourself. It's unnecessary if proper planning is done. There are estate taxes, capital gains taxes, and the fees that you pay to go through the probate, including a statutory fee to your attorney and a reasonable fee to your personal representative that are all voluntary. You choose them. So all things considered, the facts show that the shrinkage of an estate is from 30 to 60%, and it happens, as I said before, 80% of the time. So imagine that you wanted to give your kid $1 and it just became somewhere between 40 cents and 70 cents. That is what happens in an ill-planned estate. So if you already have a will, did your lawyer advise you about all of this? I will tell you, if they did not, there's one of two possibilities out there. One, they did it intentionally because they're hoping that they or their firm are going to be the probate lawyer and get paid again by taking you through probate. The second alternative is they're incompetent. They're cranking out documents from forms and they don't really understand what they're doing to their clients. Really, there are only those two possibilities, right? Except for, as I mentioned before, the person who truly wants to go through probate or whose estate only warrants going through probate and really doesn't have enough assets for us to consider one of the many kinds of trusts that are available out there. All right. So a case is filed, everybody gets notice. All the siblings, all the heirs have to sign off on multiple documents. A personal representative is appointed. They have to get letters from the court signed, and then they go start marshaling assets, which means they've got to start moving all of the bank accounts, the trading accounts, the proceeds of various things into the estate account. And then they've got to file an inventory, telling the judge everything that was owned by the person who passed away. And the judge gets to review all that and ask questions. I had a judge asking some tough questions yesterday about a probate matter. And I suspect that the tough questions were warranted in that instance, right? Then you got to tell the judge how it's planned to be distributed, and he gets to review the will and make sure you're doing it the right way. You do an order of homestead, so you get that homestead out of the probate, and And that way it can be either passed to one of the heirs or sold and distributed through the estate account. All these things take months and months and months. In fact, there's a 3-month period for creditors to have the opportunity to make a claim. And you got to notice every known creditor, and you have to publish so that other creditors have the opportunity to review. And you could be assured that every healthcare provider has somebody that's looking for those publications to see if any of their patients came through. And sometimes those are the biggest bills we see for a deceased client outside of a mortgage, perhaps for people that have a mortgage. So that case will linger on until there are no objections, we hope, but sometimes somebody does have an objection or refuses to cooperate. You've got that one, I don't know, could be a surfer dude. I've got one of those right now that's, just really all about the waves and isn't going to be bothered to sign on and join with the siblings to say, yep, let's get this done. And so you've got to go through all those formal procedures and then have a hearing so that the judge can distribute the way that the will said. So finally, after everything's distributed properly according to the will, after everything's collected, the case can be closed after a judge fully examines the inventory and accounting of the probate. So I guess the question for you to ask, and I see there are a couple questions, I'm going to hit those in just a second, would be, is it important for you to preserve what you've earned to pass it to whoever you choose? And here's the bottom line, folks. Nobody's going to do it for you. If you love your family, if you care about somebody or something, you got to fight for it. And the only way to fight for it is proper planning being put in place so that the scenario I'm describing doesn't happen. I often like to say that probate sucks away wealth. Lawyers, snoops, and fake creditors come out of the woodwork to get your money. Probate is where families fight, and not to mention that it's public record forever. So you can make your own conclusions about probate, but my professional opinion, and for most people, it really sucks. It's just not a good scenario to put your family through. I realize that's not a legal term of art, but I think everybody on this call understands what I'm saying. So estate planning should be about keeping all or as much as possible of what you've earned for who or whatever you want to share it, and to share it when and how you want to. Okay. So as much as possible, hey, there are mandatory taxes out there, and we encourage our clients to pay them. We live in a great country, and we need to pay our fair share. However, we don't agree with paying voluntary taxes. We try to help our clients stay out of that situation. We are in the process right now of helping a business owner with a sale and minimizing the gains on that sale in all the ways that are legal. So listen, if you want to avoid probate, I'm going to give this offer to those of you that are on this call. If you want to avoid probate, set up a discovery session with us, probably with me personally, and I'll waive the fee for that. There's typically a $425, $450 fee associated with that, which is for an hour. And I'm going to waive that because I just really, guys, I feel really strongly that everybody should have their personal situation examined so you make the best decision for your family. There will be no fee for that session. Of course, if you choose to go forward and work with us, we will quote you a flat fee to provide the appropriate services to you. I am trying to look ahead to see what I'm going to teach next week. Aha, we're back to homestead. Homestead is a very important asset protection and tax limitation possibility in Florida. So that's what we're going to talk about next Thursday morning. I have a couple of questions already. If anybody else has them, I will be delighted to take them. I realize I'm running right up against the 30-minute mark, which I try to keep it to. So let's see. Looks like I have two questions, and thank you so much for asking. What are the basics needed along with a will to avoid probate? Excellent question. And be happy to go over your specific situation in the discovery session I just mentioned, where we talk about your particulars. But really, the building block of your planning is to have a will and a living trust. It's a revocable trust. So you lose no control, but the minute that you're finished on this earth, you've appointed someone else to be in charge of your stuff. Very little court involvement. In fact, you file one notice with the court that there is a trust, creditors are out of the way, and you go forward to distribute in the manner you wish, which is the only way that you can control who gets what and when after you're gone. Can't do that with a will. So basically, you've gone from the most basic plan, which is with a will, to a revocable living trust plan, which will keep you out of probate. A lot more detail on that, but I think that's the answer to that question. So, okay, as a general rule, if you have more than 70,000, you need additional documents than just a will. All right, I'm willing to say, as a general rule, yes, but not always. And since I've offered a free chat, I would much prefer to answer that question for you particularly than as a general rule. So, oh, I got a perfect. I get a little star on my forehead. You're so welcome. And thank you for posting that. Actually, sharing information is something I really, really love doing. And I appreciate that feedback. Oh, I'll love to see you next week. Good. Our number is 241-1113. www.rocksolidlaw.com. I'm John Miller. I absolutely love helping folks, educating folks, and what the law firm I've developed over the last 30 years stands for in our community. Thank you for joining me. If there are questions that you just didn't want to have answered on the general chat board, I totally respect that. Please write me at questions@rocksolidlaw, and we'll get an answer back to you. I see one more thank you, and you are so welcome. And that's a friend that I see out at some of the best music events in town. And so I hope we'll be seeing each other soon, because I sure do miss live music. You guys have an awesome week. We'll see you next Thursday to talk about homestead. And of course, I'm going to leave you with the Commodores. Have a great one. John Miller, Rock Solid Law.